Good afternoon. I've had quite a lot of questions asking me, in theory, could Vanzan be brought into a complaint? Could Blake Lively, could Ryan Reynolds, New York Times, could any of them be brought into a complaint? I think more specifically, Jen Abel's second amended complaint. So I put together some slides and I was just going to go over that because I don't know for sure. My starting point is I do not know that any of this is going to happen, but I do like to explore possibilities. And I think what happens on Thursday, how Wayfarer respond to the New York Times in their state case, will be interesting. If they ask for a stay, for instance, that will lead me to think something's going on. But in theory, could all these entities be brought into Jen Abel's amended complaint? And I wanted to look at the relation back doctrine. So the relation back doctrine serves as a critical procedural safeguard in New York civil litigation. It allows claims or parties filed after the statute of limitations has expired to be treated as if they were timely filed from the outset. The doctrine is formally codified in New York civil practice law and rules under sections 203C and 203F. It provides a structured framework for courts to apply this equitable principle. At its core, the doctrine strikes a delicate balance between the strict enforcement of time limits, which promotes finality and protects defendants from stale claims, and it balances that then with the imperative of fairness to plaintiffs who have made honest errors in their pleadings. And just kind of as an analogy, how could that apply with Jennifer Abel? Okay, so Jen Abel brought her action against Stephanie Jones. The causes of action that were asserted against Stephanie Jones were all timely for statute of limitation purpose. But we have now gone through discovery, and if, for example, very hypothetically, Jen Abel has learned that other parties, whether it be Vanzan, whether it be Lively, whether it be Reynolds, whether it be the New York Times, anyone or a combination of them, or anyone else, played a material role in the facts and circumstances leading up to the claims asserted in the complaint. So with that knowledge, she now wants to amend her complaint. Well, I mean, she's got the opportunity. She's being given the opportunity to do that anyway because the claims that she had against Stephanie Jones were dismissed without prejudice. So now Jen Abel is going to be amending her complaint anyway. So we have an amended complaint, and she wants to include claims against these potential other parties. They would become new defendants. The claims that she intends to assert against them, they are time barred because she has not already asserted them. So now we're out of time. Is there a way to bring, for Jen Abel to bring these untimely claims against these prospective new defendants she wants to bring in? And the answer is yes. If they relate back to the claims asserted in the original complaint against Stephanie Jones. So if the claims that she wants to bring against new prospective defendants, such as Vanzan, relate to the claims that she originally brought against Stephanie Jones, then under this doctrine, Jen Abel can bring them into her second amended complaint. That is where we are. So under the relation back doctrine, Jen Abel can incorporate new defendants as long as the claims are relative to the original claims she had against Stephanie Jones. And the relation back doctrine comes under civil practice law and rules, 203C, that covers united in interest. Claims against defendants or co-defendants who are united in interest are deemed to be interposed at the time the original action is commenced against any of them. This provision recognizes that parties sharing common legal interests should be treated as a collective unit for timing purposes, preventing plaintiffs from being penalized when adding closely related defendants. And then, sorry, Mia keeps distracting me. Civil Practice Law and Rules, 203F, that refers to amended claims. An amended claim relates back to the date of the original pleading if the original complaint or counterclaim gave notice of the transactions, occurrences, or series of transactions or occurrences to be proved pursuant to the amended pleading. This ensures that defendants who had fair warning of the factual basis for claims are not unfairly advantaged by technical pleading defects. So there is a three-part test for adding new parties under Bisono and Kupal, 1995 case. First, same conduct standard. The newly asserted claims must arise from the same conduct, transaction, or occurrence as those set forth in the original complaint. This ensures a common factual nucleus connecting the original and amended pleadings. The second step, unity of interest. The new party must be united in interest with the original defendant through vicarious liability or other joint legal relationship. And importantly, the new party will not be prejudiced by the delay in being named. And then the third step is constructive knowledge. The new party knew or should have known, but for the plaintiff's mistake as to the identity or proper naming of the parties, the action would have been commenced against them as well within the applicable limitations period. And I think there's no denying the knowledge there that, Vanzan, whoever was the CEO for Vanzan, Lively, would have known that had Jen Abel known from the start about Vanzan, how her data was obtained, how it was passed to Stephanie Jones, they definitely would have been included in the claim. And the whole point of the way that Vanzan was carried out was for it to fly under the radar and to go without people knowing about it and getting notice. So I don't think there's any dispute that that knowledge is there. So there is a landmark case in this, Nemeth against K. Tooling, 2023 case. This was a property dispute involving landowners and businesses in Hancock, New York. The Court of Appeals delivered a landmark holding. The relation back doctrine applies even when the plaintiff actually knew the identity of the proper parties, but made a mistake in naming or designating them in the original pleading. The court emphasized a plaintiff protective approach, prioritizing the avoidance of harsh statute of limitation bars when defendants suffer no prejudice from the amendment. This decision expanded the doctrine's reach beyond mere ignorance to include naming errors. So that just broadened further the relation back doctrine. It has been used recently in the case of Bisono against Mist Enterprises. Now, so what happened here is it was just a motorcycle accident, a 2024 motorcycle accident, and there were complex party addition issues. There were multiple defendants and corporate entities involved. And the court applied both Bisono and Nemeth principles to determine unity of interest between individual and corporate defendants. Now, remember, Vanzan is the corporate, Lively and or Reynolds are the individual. That is that's the relationship. This would have been handy if Wayfarer had a way back to amend their claim, for instance. The fact that they have already sued Lively and Reynolds, they would have been able to, if they were able to amend their complaint, they would have been able to rely on this principle, this ruling, to bring Vanzan. Claims against corporate defendant related back to timely sued individual defendant. That was the ruling. If Wayfarer, now the time is, once the judge enters final judgment, Wayfarer may consider motion for reconsideration based on new information, and this may be something that they think about. I don't know. Let's have it. So there are practical implications for litigants. Firstly, error correction. It enables the correction of pleading errors without losing meritorious claims to procedural time bars. It provides a safety net protection for honest mistakes whilst encouraging thorough initial pleadings. And then judicial scrutiny. The courts carefully weigh notice and prejudice before permitting relation back. Limits and considerations. Of course, it has them. Unity of interest requirement. So there is a unity of interest standard, demands close relationship between parties, typically established through such relationships as vicarious liability, employer-employee, that is. Agency, we heard Wayfarer refer to Ryan Reynolds as an agent of Blake Lively. Shared corporate control or other joint legal interests. And mere business associations or tangential connections are insufficient. Mistake, not mere knowledge. Plaintiffs cannot rely on relation back if they simply possess factual knowledge without an actual mistake regarding party identity or legal status. Strategic delay or deliberate omission defeats the doctrine's application, and I don't think that's here, because even though Jen Abel amended her complaint immediately after Vanzan was discovered and didn't include him at that point, she didn't have the discovery that would have told her who is Vanzan, what's their corporate structure, who's the CEO. There's a lot of information still missing, which would have been found during discovery, including the actual deposition of a corporate designee from Vanzan, who we still don't know who that is, but I can't imagine there's many people. No undue prejudice. So amendments cannot cause undue prejudice to defendants. The courts examine whether delay has compromised the defendant's ability to defend, including loss of evidence, fading memories, or changed circumstances that materially disadvantage the defense. I don't think that's the case, because Lively is, the discovery has been going on with the same defendants largely. They're relevant in the Lively and Wayfarer lawsuit. They're relevant in the Wallace and Lively lawsuit in Texas. There are loads of lawsuits actually, so nothing's been lost. There's no prejudice for their ability to defend. The only thing that might change circumstances is Ryan Reynolds is now the CEO, but I still don't see an issue there at all. I don't think that'll make any difference. There is he's married to Blake Lively. So Blake Lively was the original CEO, Ryan Reynolds now being the CEO, there's a marital relationship there. That in itself is not sufficient to find a unity of interest, but when the spouse is acting as the other spouse's agent while committing the tort, or when the married person consents to, instigates, participates in, or coerces the spouse's action, then there will be a finding of unity in interest. And that is actually, that was a ruling in the case of L&L Plumbing and Heating against DiPallo, just if anyone was interested. So I think they can make it work because of the marital link. Okay, visualizing relation back, the timeline. So this is how it operates in practice. There's an original filing. The complaint is filed against defendant A before statute of limitations expires. Obviously, defendant A, as we said, is Jen Abel. Then the statute expires, the limitation period runs out, normally bars new claims or parties. An amendment is filed, right? So forget the first amended. We'll look at this as the second amended that's coming, right? The plaintiff moves to amend complaint, adding defendant B after deadline. Then relation back. The court applies doctrine. Amended claim can be treated as filed on original date. The result is the claim against defendant B is deemed timely, despite post-deadline addition. So we have defendant A at the original filing at the first point, and then adding defendant B at the end of where it's result. And that's just kind of the steps. I'm hoping that I'm trying to make this as not technical as possible, but visual representation demonstrates the doctrine's temporal effect. Whilst the amendment occurs after the limitations period has expired, the legal fiction of relation back treats the claim as if it was asserted on the date of the original complaint, thereby satisfying timing requirements. So, conclusion. I hate adding these slides to StreamYard because they always change. Conclusion, relation back doctrine as a fairness mechanism. So the relation back doctrine under CPLR 203 embodies the law's commitment to substantive justice over rigid procedural formalism. It protects plaintiffs from losing meritorious claims due to technical errors in party designation or claim foundation, whilst simultaneously safeguarding defendants' fundamental right to timely notice of claims against them. This careful equilibrium reflects the court's recognition that the statute of limitations serves important policy goals, promoting diligence, ensuring evidentiary reliability, and providing repose, but should not become a trap for the unwary when core fairness demands flexibility. So we've got plaintiff protection. It protects loss of claims from correctable pleading mistakes. Balanced approach. Courts weigh fairness against the defendant's right to timely notice. And strategic essential. Mastery of CPLR 203 is critical for effective civil litigation in New York. So, do I think this could happen? I think it could. Do I know? I don't. No one knows. But I do think that there is concern amongst Lively and the New York Times. I think the fact that New York Times requested Judge Lyman enter final judgment so they could then file for the fees tells me that they may be a little bit nervous. I don't know for sure, but I mean, they could have just sat and waited out what they're asking for in terms of fees. I've seen it's either 135 or 150. I don't have it in front of me right now. So it's like, it's not a lot of money they're asking for. And Wayfarer have, strategically twice now declined to respond. They didn't respond to their original request for the judge to enter final judgment, and they didn't respond to Judge Lyman's invitation for them to say why he should not enter judgment. They didn't say anything, and as it's not a bad thing to do, because then it doesn't commit them to anything that could limit their scope of appeal. But I'm going to leave it there. But I think something's going on. I just don't know what. But if I was to say what is my best guess, I think the relation back doctrine may become relevant. Have a good day.